Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers, where I challenge you to replace a 10th of an hour of billing with a 10th of an hour of learning. For today's episode, episode 7, this is going to be the first in a series called Great Cases, where we look at various cases that have significance in the tax and estate planning world. And for today, we're going to look at a recent 2020 tax court case, Moore versus Commissioner. This is part 1 of many discussions on this case. So before we get into the case itself, there's two classic estate tax battles that decedents' estates fight with the IRS. One, what is the fair market value of gross estate assets, including discounts? That battle tends to be fairly settled and resolved through qualified appraisals. So the second battle is, did the decedent give away assets during life but retain control? Now the second point is becoming the more popular method of IRS challenge to the estate tax liability, especially recently in cases where there are gifts through a family limited partnership. And this is illustrated with several other legal principles coming into play in a recent U.S. tax court case, Estate of Howard Moore versus Commissioner. So this is a classic case that illustrates all that can go wrong with bad planning. That's why we need more than one discussion to really do this case justice, pun intended. So here's some key facts real quick, and they're so comprehensive that I can't hit all the high points, but it's important to know that Mr. Moore was in bad health, and within 4 days of leaving the hospital for a heart attack, he executed a comprehensive estate plan with a revocable trust, a family limited partnership, a charitable lead annuity trust, a family foundation, and 3 separate irrevocable trusts, all with different purposes. So his attorney charged a whopping $320,000 in fees for all this work. Now it's important to note that most of Mr. Moore's gross estate was in farmland in Arizona. And somehow, in this 4-day period, Mr. Moore and his attorney got all of these documents and transfers of farmland completed. Now, why is this significant? Because prior to the hospitalization, Mr. Moore had been negotiating a sale of the farmland, and just 5 days after he completed his estate plan, the farmland was under contract for sale, and then it actually sold about 6 weeks later. So there are several tax challenges and more, because this case had it all. It had end-of-life transfers, deep discounts, retained interests in gifted assets, family disputes, attorney fee disputes, and the list goes on and on. Because this is so complex, we're really only going to look to one issue per day in our series of discussions on Moore. Otherwise, it would take several tenths of an hour to do this case justice, as I mentioned. So for today, we're going to look at retained use in the case of an intervening sale to a third party. Now, before we get into the actual discussion on Moore, it's important to note that generally, under Code Section 2036A, if you give away an asset during life, but at the time you give it away you retain the use of it, then the IRS can essentially ignore the gift for estate tax purposes. So what that means is that if the property goes up in value between the date of the gift and the date of your death, then this growth in value will become subject to estate tax in your estate, which flies counter to the whole purpose of making lifetime gifts from a transfer tax planning perspective. However, if there's a bona fide sale of an asset, the IRS doesn't care. Now, we're not going to get into the actual terms and conditions of a bona fide sale in the eyes of the IRS today in the safe harbors. But it's important to note for next time that Moore invoked 2 potential bona fide sales, but we'll look at the lowest hanging fruit in that after Mr. Moore had sold the farm to a third party, somehow in the real estate contract, he retained the right to live on the farm and keep managing the farm for life. Now, we only lived about a month or so after the farm was actually sold, actually less than 2 months after the sale closed that he died. But it's important to note this was a sale to a third party. Most of the time when the IRS is challenging a bona fide sale, it's looking at it from the perspective of a sale to like a family member or a related party. So you'd think that the IRS and tax court wouldn't care in this case about retained use. In other words, if it was sold to a third party but he kept the right to live there, then the IRS is going to assume that somehow that's reflected in the sale price and it's an economic deal at arm's length, and there's no worry about a retained use, because usually you only see retained use come up in a gift tax scenario. But there were other facts here that allowed the tax court to really skirt around this intervening sale to a third party. First, the sale wasn't the first step in all this process of planning. So the IRS and the tax court focused not on the sale itself, but first on the transfer of the farmland to the family limited partnership. And because of this, there was an assessed retained use at the time of the initial quote-unquote gift through the family limited partnership, especially because Mr. Moore kept a 1/5 interest in the farm through the family limited partnership. So look at what's happening. He gave away all his farmland, he kept a 1/5 interest, but he kept the right to use and manage the entire 5/5 of the farm. So because of that, there was a retained use issue here. Not only that, once the sale had closed, Mr. Moore continued to treat the family limited partnership itself as his own asset. Even though he wasn't a general partner, he didn't have any authority over the partnership, and he only had a 1/5 interest, which wasn't a majority interest, he still used the cash proceeds of the sale of the farm in the family limited partnership as his own. And importantly, when the sale was made, Mr. Moore carried out the sale even though he didn't have any authority to under the family limited partnership or its documents. So, as we're going to see later, the intent here was that he was supposedly on paper shifting ownership and control to his family members, but the actual economic reality was that he really did retain control even though he only held 20% as a limited partner and wasn't a general partner. So, because of all these facts, they were bad facts, and the IRS found that there was a retained use issue here, even though the farm had been sold in the interim to an outside third party. So what are our key takeaways here? One, if a client is of advanced age and of ill health, it might not be a good idea to engage in this type of complex planning, because in this case and several others recently, like Powell, Cahill, a few others we'll cover in the future, we keep seeing taxpayers getting burned with deathbed transfers or transfers in the last few months of life, especially to family limited partnerships and through split dollar arrangements. So, if you're going to create a family limited partnership, or any entity for that matter, it's important to respect the formalities of that entity. Don't treat it as your own, and don't use its assets for free. You have to respect the ownership is now in the entity, you don't control it, and you have to pay fair market rent or whatever if you use any of its assets. And if you set up an entity in this way, a subsequent sale of the assets to an outside third party is not going to absolve you of your sins of retained use under Code Section 2036A, because the retained use is assessed, as we're going to see later, from the time of gift and not just at the time of death. So there's a corollary under Code Section 2038A, which we'll cover later, which also assesses retained interests at the time of death, and you're usually seen in conjunction, but in this case we focus just on 2036A. And either one in isolation can be enough for there to be a retained use issue for estate tax purposes. So that's it for our first discussion today on the estate of Howard V. Moore versus Commissioner. If you have any questions, as always, or topic suggestions, feel free to email me at griffin.bridgers@gmail.com. But in the meantime, thank you for joining me for this episode 7 of The 10th of an Hour, and I look forward to seeing you in the next